My name's Brad Dixon. I'm a trial lawyer, and today I want to talk to you about bails and bonds. Now, bails and bonds are technically two different things, but we use the two words interchangeably. A bail is the amount of money that you would pay to a sheriff's office in order to be released from jail while you're waiting for trial. A bond is the amount of money or the obligation by a bail bondsman to pay your full bond in the case that you don't show up. A bail bondsman is going to charge a percentage of that bail amount in order for them to post the bail for you. And the trick is, with a bail bondsman, you're not going to get that money back. If you post your own bail, however, if you show up to trial, you're going to get all of your bail money back. And that's the purpose of a bail and a bond, is to guarantee that you actually show up for your court dates and your hearings and your trial eventually. Now, there's three different kinds of bails. There's a cash bail or bond, there's a property bail or bond, and then there's an OR or own recognizance bail or bond. The own recognizance is obviously the best one. That's where the judge or the sheriff lets you sign your name, agreeing that you'll show up later on at trial, and you're released. A cash bond is an amount of money that you would pay guaranteeing that you'll show up to trial later on, and if you don't, that cash is forfeited to the state or the county. A property bond, which by law has to be twice the amount of a cash bond, means that you put up a piece of your property and a lien is put up against it, and if you don't show up to trial, then the property is taken by the state or the county and sold to fulfill that bail or bond amount. Now, whenever you go to a bail bondsman, the bail bondsman ordinarily is going to use the property bail number to establish how much you have to pay them. So, for example, if a bail bondsman charged 10% fee off of the property bond and your bond was $10,000 cash, $20,000 property, then the bail bondsman would look at the $20,000 property bond and charge 10% of that. So that'd be $2,000. So you would pay $2,000 to the bail bondsman. The bail bondsman would put the rest up for the bail, and you'd be released. Again, the catch is later on, if you show up to trial, if you pay your own bail or bond, you get all the money back. If you pay a bail bondsman, that 10% that you put down, that goes to the bail bondsman, and that's payment for their services, and you don't get that back. Now, the other big question is, how long does a person sit in jail before they're actually entitled to a bond, or they find out what their bond is? Well, if you're arrested without a warrant, so there's no arrest warrant out for you and you're just arrested. For example, if you're pulled over, you have a DUI and you're arrested. If you're arrested without a warrant, you have to have a first appearance in front of a magistrate within 48 hours. And at that first appearance, the magistrate sets your bail or bond amount. If you're arrested with a warrant, so the police have obtained some sort of arrest warrant based on probable cause and they arrest you for that, you have 72 hours to appear before a magistrate. Now, what happens at this magistrate first appearance is the magistrate looks at your charges, they look at the available evidence, and they determine what the bail amount should be. In many counties, many jurisdictions, there's a set bail amount that's already established by the judge. So, for example, if it's a particular kind of offense, then the bail amount is pretty well already set. And in that case, you can be informed of that at the very moment that you're booked, and you don't even have to make an initial appearance before a magistrate. You can just pay your bail and be released. Now, if you don't receive a bail in front of the magistrate at your first appearance, it's probably because the magistrate doesn't have the authority to set bail because you've been charged with a particular serious offense. And those serious offenses include murder, sex crimes, manufacture, distribution, sale of drugs. Those are the big ones. So if you're charged with those kinds of offenses, a magistrate by law cannot set your bail. They don't have the authority. So they have to send the case up to a superior court judge and the Superior Court judge can set your bail for you. Now, what you have to do if that's the case is you really have two options. You can either, one, wait for 30 days, and if 30 days pass and you still haven't received a bond or bail, you haven't made an appearance in front of a Superior Court judge, then the magistrate sends in writing notification to the Superior Court judge telling him or her that bond or bail couldn't be set due to the seriousness of the offense and that the Superior Court needs to set a hearing. If that happens, then the Superior Court has to have a hearing for you within 30 days after receiving that notice. And at that hearing, the Superior Court judge will determine what the bail amount will be. The other way to go about this, if the magistrate at your first appearance doesn't set a bond because he or she can't due to the seriousness of your alleged offenses, then you can request a hearing yourself before a Superior Court judge by filing a motion requesting a bond hearing. If that's the case, then after 10 days after the motion has been filed, then the judge has to set a hearing date, and you have your hearing date. That's the more common way that it's done, especially when somebody hires an attorney. So for example, if I get a call from a new client who tells me they were just arrested for a drug distribution offense, my very first thing that I do is I file a notice of appearance with the court, I file a motion for a preliminary hearing, and I file a motion for a bond hearing. Now the bond hearing and the preliminary hearing are two different things. A bond hearing obviously allows the judge to consider a number of factors to determine whether or not you get a bond. And he looks at things like whether you're a flight risk, whether you're a danger to the community, whether there's a danger that you may obstruct justice in some way. On the other hand, a preliminary hearing, in that hearing the judge looks at, is there enough evidence in this case to continue this case forward to a trial and to hold the defendant in jail until then. So we're really looking at two separate things. Both are extremely beneficial to you because at this point in time you have no idea what the state's evidence is, and you won't have an idea until your arraignment, at which time you can file a discovery request. So it's really important that that initial motion, that initial action is taken so you can get your preliminary hearing, have the arresting officer or an investigating officer testify about the case, ask them lots of questions to determine what evidence there is, and then after that preliminary hearing is over, then we have the bond hearing and we ask the judge to set your bond. If you have more questions about bail or bond or any other kind of criminal law action or issue, feel free to give me a call. Thanks.